CVS and Meera Shahana of Department of Law, Central University of Kerala, to present Unveiling the Wings of Reasonable Restrictions with all to Freedom of Press.
Okay. Good afternoon, everyone. The topic that I'm going to deal is about unveiling the winds of reasonable restrictions withheld to freedom of press. So, before going to the core topic, I would like to begin my presentation by citing a phrase which has a story behind it. And the phrase which I'm going to cite is the sword of a Damocles. Actually, this phrase has got some connection with the present topic that I'm going to discuss. Am I audible? So before going to my core topic, as I said already, I would like to discuss on a phrase, which is the sword of a Damocles. Actually, Damocles is a character which appears in an anecdote by a Roman orator, Cicero. And according to the story, Damocles one day had told the king that he was truly fortunate as a great man of power and authority. And in response to this, the king actually offered to switch his throne with the Damocles for one day so that the Damocles could taste the fortune that he has told him. And the happy Damocles accepted the proposal made by the king and sat on the throne of fortune, which was surrounded by countless luxuries. But the king asked his men to hang a sword above the throne, which is tied to a single hair of horse tail to evoke the sense of what it is like to be a king. Though having much fortune, always having to watch in fear and anxiety about the dangers that might try to overtake him. Just like a sword is hanged over the throne of fortune, the restrictions are hanged over the freedom of speech and expression, and in turn, the sword is hanged over the press. And as Rajiv Gandhi rightly pointed out through his words, freedom of press is an article of faith with us, sanctioned by our constitution, validated by 4 decades of freedom and indispensable to our future as a nation. Though Indira Gandhi, the mother and the son, had varied of opinion with regard to the freedom of press, one thing which pointed out is that it is an indispensable to our future as a nation. The control of press, which it have in our daily life, need to be looked in as a day without knowing what is happening around us is very difficult. Scholars have compared a free press as oxygen for the democracy, without which it cannot survive. In a democratic country like India, the role of press is vital importance as it makes the other organs accountable to the acts which they do, and the people are made aware about the happenings in the country. It makes the people think about what is happening around them. But nowadays, the state approaches the press as a sleuth hound, targeting, restraining, and unreasonably imposing wide restrictions to prop up with the political ideologies of the state. The questions raised by the press wakes the intolerant behavior of the state, and the unrivaled state imposes the restrictions in such a way that the so-called interpretation given to the restrictions sips the mouth of the press. Now I would like to move on to the pinnacle of judicial creativity, freedom of press. The freedom of speech and expression, which is often being called as a mother of all liberties and the foundation stone of every democratic society, which constitute inalienable human right. The capacity to express oneself freely and learn from others is at the heart of free speech. As the Constitution of India guarantees freedom of speech and expression as fundamental right, the philosophy behind the freedom of speech and expression lies in the preamble, where it ensures to all the citizens the liberty of thought, expression, faith, and belief. The freedom with restrictions, which is being imposed for reasons of national interest or sovereignty and integrity of India, the security of the state, friendly relations with the foreign states, public order, preserving democracy, decency and morality in relation to contempt of court, defamation laws, or incitement to an offense. In this famous case of Ramesh Thapar versus State of Madras, Justice Patanjali Shastri has rightly pointed out that there can be no doubt that freedom of speech and expression includes freedom of propagation of ideas, and that freedom is ensured by freedom of circulation. Liberty of circulation is as essential to that freedom as the liberty of publication. Indeed, without circulation, the publication would be of little value. And in Srinivas Bhatt versus State of Madras, the interpretation of the words of freedom of speech and expression, which is stated that the term freedom of speech and expression would include the liberty to propagate not only one's own view, but also the right to print matters which are not one's own, but have either been borrowed from someone else or are printed under the direction of that person. And at present, what we can say is, what we can infer from the situation is that the judiciary have never turned its eyes towards the freedom of press and has always raised its eyebrows towards the authoritarian centers and protects the freedom of press in the interest of democratic framework. Now, moving on to the exigencies of reasonable restrictions, the test which has been conducted by the judiciary. Now, stating the law Denning, the press is the watchdog to see that every trial is conducted fairly, openly, and above board, but the watchdog may sometimes break loose and has to be punished for misbehavior. Yes, of course, we cannot say that there should be a complete freedom to the press. There should be some restrictions, but the question is that how these restrictions are interpreted by the organs, that is by the state. How these interpretations are interpreted, how these restrictions are interpreted by the state to actually satisfy their needs. And in Madras versus Roe, the Chief Justice Shastri said, it is important to bear in mind the test of reasonableness where prescribed should be applied to each individual statute impunged, and no abstract standard or general pattern of reasonableness can be laid down as applicable to all cases. According to him, in all different cases, the situation should be analyzed and a general pattern of reasonableness cannot be laid down. Now, moving on to the Maneka Gandhi case and A.K. Gopalan's case, in this, the courts must protect the fundamental rights by taking into account the act's scope and provision, as well as their impact on the fundamental rights. The Supreme Court used the effect test in Maneka Gandhi case and several other cases. The object of law or executive action is irrelevant when it infringed a fundamental right, although its subject matter may be different. The test to be applied is not whether a judge personally considers what a particular restrictions is unreasonable, but whether a reasonable man would necessarily consider them unreasonable. For adjudging reasonableness of restriction, the court considers such factors as the nature of right alleged to have been infringed, the underlying purpose of restrictions imposed, the extent and urgency of evils thought to be remedied thereby, and the disproportion of the imposition and the prevailing condition at that time. Now, moving on to the ready-made excuse of reasonable restrictions with reference to the current scenario or the current climate. I have actually referred to some of the current instances whereby I would like to discuss. We have actually celebrated our Azadi Ka Amrit Mahotsav very recently, but I would like to raise a question whether we have received the Azadi. Have we received the complete freedom that we claim? So this is a question to be answered. Though India being a democratic country, which always gives values to the fundamental rights of citizens, the road to achieve the liberty as enshrined in Part 3 of the Constitution of India is very long and a rough one to achieve. The intolerant state machinery has always used the restrictions imposed under Article 19, Clause 2 to satisfy its requirements, and in order to defeat the freedom, the same has been misused by the state machinery. And all these instances, from Anuradha Basin have stated to Vinod Dua versus Union of India and to the News 18 of India, in all these instances, the state has been misused these restrictions. And as you all know about the Anuradha Basin case, it is a restriction. It is a restriction on the usage of internet during the abrogation of Article 370. And in Asif Iqbal Naik's case, the Jammu Kashmir High Court, while considering the petition, observed that no fetters can be placed on the freedom of press by registering an FIR as he was performing his professional duty by publishing a news item. We can see from this instant case that how a publication of a news actually ignites the intolerant behavior of the state. And also a recent issue which has happened in Kerala, that is the ban which is imposed on the Media One. And in this case, Madhyamam Broadcasting Limited versus the Union of India. In this case, actually the state approached the situation as the state banned the right of the media, that is the Media One, which is actually the petitioner here. And the respondent contended that this, by banning, the justifying the act of ban as the same was to protect the national security and public order. And to state the reason for the same, the state approached the High Court by in a sealed cover stating its reason without even giving a chance to the petitioner to actually justify without even giving a chance to the petitioner to justify that act. And when we considering the India's position, that is, India holds 142nd position in the world press freedom. And this has been actually raised in the parliament by Mr. Manish Tiwari, raised certain questions in the parliament. And while dealing this question, actually, he asked a question that penalizing of the journalists by the state, invoking the draconian legislature of Unlawful Activities Prevention Act, and also under the Indian Penal Code. And this can be referred from the recent issue of Siddiq Kapan's case. Siddiq Kapan has been behind the bars for almost 2 years, and he actually got the bail only very recently. And we can see that he was on his way to report a case, and he was being arrested under the draconian legislations. And in Vinod Dua's case also, he made a statement against the government through his YouTube channel. So I would like to actually conclude by actually preferring some recommendations which gentles the recent storm. That is the recent issue of freedom of press, the restrictions imposed. Lord Denning wrote, "We do not fear criticism, nor we resent to it. But it is always the state who fears the criticism. And it is always the state who should actually uphold the democratic character of our constitution." And as some suggestions to be made, when we consider of registering an FIR against the journalist for his or her publication of a news article, cartoon, opinions, or photographs, the same should be taken into consideration by after consulting with the press council, so that it can be avoided of misrule of the state governments. And the law being dynamic concept should need modifications and improvements with the changes in the society. And the legal reformation in the media sector is a necessary requirement of the time, and the draconian legislations used against the journalists to withhold them from reporting the news should be reframed to meet the standards and making it more transparent and avoid the misinterpretations given by the state machinery to achieve their goal. And I would like to conclude by stating the words of Thomas Jefferson: "If it were left to me to decide whether we should have a government without newspaper or newspapers without a government, I should not hesitate a moment to prefer the latter." Thank you.
Thank you, Sreehari.